We've got one matter for trial this morning, which is Pellegrino versus Giordano. Can I get plaintiff's counsel appearance, please?
Yes, Your Honor. Zachary Zarme here for Plaintiff Paul Pellegrino.
Kevin Morensky as well for Paul Pellegrino.
Faden on behalf of Tracy Giordano.
Okay. All right. Give me just one moment to make a note here. So Mr. Faden for Ms. Giordano, and Ms. Giordano is present as Tracy's iPad, correct?
Yes.
And I believe Mr. Pellegrino is iPhone.
Yes, ma'am.
All right. And then who is Joshua Valletta?
Your Honor, he's my first-year intern. He's just attending for his own edification.
Okay, very well. So he's a part of Mr. Zarme's law firm. And we've got Madam Clerk. Good morning, Madam Clerk, and welcome. Okay, so we have a claim and a counterclaim, and the plan is to get through all of that in a one-day non-jury trial. The last time we spoke on some discovery issues, I let the parties know that you can file some motions in limine if you believe there's a problem. I have not received any, not seen any. I also have not received any exhibits. Madam Clerk has indicated that she did late yesterday, but I don't believe any of those have been given to me. So in other words, I'm still on May 14 with what was in this trial, in this court file, and certainly ready to proceed. But Mr. Zarme, I was a little surprised as I kept checking the cases heading to trial and there was no activity, radio silence. I was actually a little bit curious last night whether y'all were going to show up. So is there anything preliminary that plaintiff needs to address, or can we just start with the testimony?
Yes, Your Honor. Just preliminarily, a motion in limine was filed last night, albeit late last night. I don't believe that the clerk's office got an opportunity to docket it. It's my understanding that Mr. Morensky recently sent a courtesy copy to Chambers. And so if we could briefly address that. Hopefully there won't be too much there given the court's previous order. We essentially tracked it given the deficient interrogatory responses. And it was our understanding that the court's order was that it was going to exclude evidence stemming from the deficient discovery responses to prevent a trial by surprise. And the motion limine effectively covers that. And so if we could be briefly heard on that to deal with some evidentiary issues, that would be phenomenal.
Okay, I continue to smile.
Brief response, Your Honor.
Mr. Morensky sent this to my assistant at 8:58 a.m. I continue to shake my head a bit at the professionalism or lack thereof. That's not how this is done. Y'all are both a lot younger than I am, and I'm wondering if you ever had an older attorney standing over you and telling you no. Sure, you can respond, Mr. Faden. I have no idea what we're even talking about, but go ahead and respond.
Yeah, I'm just going to ask for general continuance at this point, Your Honor. I've got no exhibits.
No.
Well, Your Honor, hear me out.
That's not happening. I don't even need to hear the argument on that one.
I've got no evidence, no exhibits. I have nothing that they're going to give today. Nothing's in the court file. And they filed the motion at I didn't even finish reading it yet. They filed the motion at 1:30 in the morning. I haven't even finished reviewing it yet.
Yeah, and here's how that's going to go. Exhibits that haven't been properly disclosed and exchanged aren't coming in. A motion filed at 1:30 in the morning and sent to the court 2 minutes before trial isn't being heard. So your objection is sustained in that regard. We're going to get through this trial today. Both sides had more than enough notice. In fact, y'all have been pushing me to get you to trial faster. We're not continuing this. I will keep the playing field level based on the lack of professionalism by both sides. That's going to be a full-time job for me, but I'm okay with that. But we're going to get through this case today. This is something that for the good of these two human beings are just trying to end their relationship. We're going to get them through it. So, Mr. Zermay, I will not be entertaining the motion in limine. It may well be that objections are simply made along the way, and we'll deal with them in that regard. But no, you don't file motions at 1:30 in the morning before a trial. That's not how this is done. Anything else preliminary from plaintiff?
Not at this stage, Your Honor.
All right.
And Your Honor,
anything
just concerning the
preliminary-
exhibits, concerning the exhibits, those were tendered to the clerk yesterday. And specifically, they are two exhibits, the hold harmless agreement and the automobile lease. Mr. Faden has received those through discovery previously.
All right. It's the hold harmless that was attached to the complaint
Correct. Yes, Your Honor.
and the vehicle lease. Mr. Faden, do you anticipate having any objection to either of those documents?
Not the agreement that was attached to the initial complaint, and it's been used in other motions. However, the lease agreement, I don't believe has properly been brought before the court.
Okay, we'll leave the lease out.
Your
I
Honor,
have a feeling Mr. Faden's going to want the lease in, so don't cross it off your list. Don't throw it away yet. But for now, we'll deal with the hold harmless agreement. When you go to talk about the lease, we'll have a fight over whether that's been appropriately disclosed. I have a feeling, like I said, both sides will need that. Let me just give you a little bit of an idea of how this should be going right now. Those exhibits should have been exchanged pursuant to my pretrial conference order quite some time ago. And what I would anticipate with lawyers who are following the rules is that the two of you would actually stipulate to the admission of both of those documents because you both need them. But let's start with the hold harmless agreement that forms the basis of the complaint and see whether we even need the lease. I suspect we won't. All right. Anything else, Mr. Morensky?
No, Your Honor.
All right. Mr. Faden, anything preliminary from the defense before I invite the plaintiff to begin their case in chief?
I would just like the plaintiff's attorneys to determine who's going to be arguing the case today as opposed to going back and forth throughout the day.
Yeah, that's actually my job. I'll take care of making sure that they follow the appropriate rules. The rules, just to remind you, since we don't seem to have a lot of facility with rules, the rules will be this, that on any given segment of the trial, only one lawyer is to be speaking. So for example, if you do the direct examination of a witness, you will be the only lawyer objecting on the cross-examination of said witness or arguing points for that one. So we've had preliminaries. I can appreciate there might have been a division of labor on those, but each segment of the trial, opening, direct, cross, close, one lawyer on any given segment of the trial for plaintiff. All right, then I'm going to invite the plaintiff. Do you wish to make an opening statement at this time?
Yes, Your Honor, and may it please the court. This case is really simple. Evidence and testimony will reveal that two adults entered into a valid and binding contract to dispose of a risky and unique asset that exposes them both to liability and continues to bind them together. Ms. Giordano, who is a party to that agreement, was required to refinance and get Mr. Pellegrino's name off of the Toyota Camry that they both leased together from Southeastern Toyota of Naples, 12th of 2020. She failed to do so by that date and breached the contract. Mr. Pellegrino has and continues to suffer damages from Ms. Giordano's breach. His damage stems from the unique liability and risk that stems from having his name on it. That being the risk of personal liability for Ms. Giordano's torts committed in the vehicle. Ms. Giordano may point to a hold harmless provision in the agreement. However, there is always risk of Mr. Pellegrino being tagged with a judgment stemming from her torts. And as the Supreme Court unambiguously held in Spokio Inc. versus Robinson, 136 Southern Court 150, risk of harm is always the basis of damages. Indeed, this unique liability and risk aside, the vehicle is unique to the parties. It was leased during the relationship, which came to a cantankerous end. And as the court knows, under Magnus v. Porter, 276 Southern 2D 250, that's out of the 3rd DCA, vehicles with a unique character and value are subject to specific performance under contracts. Under applicable case law, this unique risk and nature of the car makes specific performance of the agreement appropriate. And the alternative, if the court were to conclude that Mr. Pellegrino would be made whole by remedies at law, evidence will show the payoff value of the car, and that would be the monetary damages. And that is plaintiff's opening, Your Honor.
Okay. Mr. Faden, do you wish to make an opening at this point?
No, Your Honor.
All right. I'll permit you to do that at the start of defense case / counter plaintiff's case if you wish. All right. Then who is going to call the first witness for plaintiff?
I am, Your Honor. I'm going to call Mr. Pellegrino.
Okay. Mr. Morensky will be the attorney addressing Mr. Pellegrino, and Madam Clerk is going to swear you in, sir, if you'll raise your right hand.
The testimony that you shall give shall be the truth, the whole truth, and nothing but the truth.
Yeah.
Okay, you may proceed.
Thank you, Your Honor. Good morning, Mr. Pellegrino. Will you please introduce yourself to the court?
Good morning. My name is Paul Pellegrino. Good morning, Your Honor.
Morning.
And can you spell that for the clerk, please?
Pellegrino, Pellegrino.
And Mr. Pellegrino, what do you do for a living?
I'm semi-retired at this time of my life.
Do you have any health issues or anything else that would affect your ability to testify today?
Well, the only thing that I have going on is I'm recuperating from some surgery about 3 weeks ago. I feel fine. I believe I'm up to this, and I want to pursue it.
And what was the nature of that surgery?
Open heart surgery.
Okay, and you're feeling fine right now?
I'm okay. Yes, thank you.
Now I want to turn to this case. What do you remember about this case?
Well, basically, everything boiled down to us finalizing our relationship, her moving on with her life, me moving on with mine. The only thing that's still keeping us together, okay, is that myself and her are both mutually on the lease.
When you say the lease, what lease are you referring to?
Okay, I'm sorry, the Toyota, the car lease.
So it's my understanding that you guys entered into an agreement about a vehicle, correct?
Yes, we did.
Okay. At this point, Your Honor, I would like to bring up what's been pre-marked as Plaintiff's Exhibit A, which is the hold harmless agreement.
Okay. And Mr. Faden, let me just check. Is this something that we can just admit by stipulation, the hold harmless? You're on mute.
Yes, Your Honor.
Okay, makes it simpler, and I appreciate that. So we'll show Plaintiff's Exhibit A as admitted by stipulation. And yes, if you want to share your screen, Mr. Morensky, you can bring that up.
Let me pull that up on this monitor. Excuse me. I have it on another one right now.
Okay.
And then for the screen sharing, let me just click that button.
I do have a copy of, I can see it from the court file. So, but if you wish the witness to look at various points of it, it'll be easiest if you can share it on your screen.
Yeah, that's what I'm going to do right now. Let me see if I can. I apologize, Your Honor. I'm just trying to pull up the correct window here for the screen sharing.
Yeah, you want to probably close anything that you don't want to accidentally share. I have had that happen.
That's what I'm trying to verify right now, Your Honor, that there's, let me see if I can. Okay. Are you able to see that document?
Yeah, I am.
Yes.
Let me see if I can see it on my screen as well. I apologize. I've never actually shared a Zoom screen before, so.
You want to dry run these things if you can. But it's fine. I'm seeing it just fine.
Okay, you are seeing the agreement?
Yes.
And that is titled Hold Harmless Agreement?
Yes.
Okay, thank you. Mr. Pellegrino, I just want to turn to this Hold Harmless Agreement. Do you recognize this agreement?
Yes, I do.
Okay. How did this contract come about?
Well, part of our ending our relationship was based on getting my name off of the lease, off of the car lease. At the time that she was moving out, we had to prepare this because she hadn't done it yet. So I needed some type of agreement from her stating that she would, within a reasonable time, and we agreed on 90 days, get my name off of the car lease so that I can be separated from any financial or legal responsibility down the road, but also that we can end our relationship once and for all.
Now, I'm going to scroll down a little bit to the bottom of this agreement. Is that your signature on this agreement?
Yes, it is.
Do you recognize Ms. Giordano's signature on that agreement?
Yes, I do.
And are you familiar with her signature?
Yes, I am.
Did you draft this agreement?
No, I did not.
Who drafted the agreement?
We spoke about, she had her attorney, Mr. Sam Saad, draw up this, her original attorney, Sam Saad, draw up this agreement so that we both had something in writing and we both had some guidelines to follow.
Okay. And to date, has she gotten your name off of the vehicle lease?
Sir, as we speak right now, I am not aware of anything like that. So I'm going to have to say, no, she has not got my name off of the lease.
Has she refinanced the vehicle in her name at all?
Not that I know of. We've had no communication, so I don't know where she stands in the process of resolving this thing.
Okay. And with respect to the agreement itself, this was the entirety of your understanding about what was going to occur, what your obligations were?
That's exactly it. It was pretty simple. It was short and sweet, and seemed to spell it all out very, very basically.
I have no further questions.
All right, any cross-examination?
Yes, Your Honor. Sorry, I'm just trying to get out of the share screen so I can get back to my computer.
If you can, Mr. Marinsky, if you want to end share screen, thank you.
Yes, Your Honor.
Okay, Mr. Pellegrino, can you hear me?
Yes, Mr. Faded.
Okay. You had stated you entered into this agreement to divide up everything left in your relationship. Was that how I understood it?
Objection, Your Honor. It's outside the scope of the direct.
Okay, response?
It's directly what his client said. He said they drafted up this agreement to separate what they had left, I believe was the exact verbiage. How is that outside the scope?
This agreement was.
Well, I'm sorry, Mr. Pellegrino, you can't answer yet. You gotta wait for the judge.
Hang on just a second. Mr. Marinsky's objecting that it's beyond the scope. Why is it beyond the scope?
Your Honor, it's my understanding that he was contemplating introducing other information into evidence or eliciting other information concerning assets that were not disclosed to us via discovery that were subject to the interrogatories.
Okay, well, that's a little bit of a different issue. With regards simply to scope, I would allow both sides some latitudes. We've got a claim and a counterclaim. It's a non-jury trial. And again, I would expect counsel on both sides to stipulate up front that both sides will be able essentially to explore the claims and counterclaims as we go so that we don't have to just force Mr. Faden to recall Mr. Pellegrino. So I'll overrule the scope objection and will allow both sides some latitude so you can try efficiently to get through the claim and the counterclaim. Now, whether this is going to get into matters that haven't appropriately been disclosed is really a different issue. Mr. Marinsky, do you have more information for the court on that, or do you want to hold and raise the objection if and when we figure out?
I'm going to hold and raise the objection if and when we get to that point.
Okay, Mr. Faden, I'll let you just start over then and let's see where we go.
Okay, Mr. Pellegrino, on your direct testimony, you had mentioned that the purpose behind this agreement was to help you guys break up and separate everything. Was that correct?
No, the purpose of this was to finalize everything we already agreed upon. And this was the last piece of the puzzle to eliminate and dissolve our relationship.
What else did you agree on? What was part of this? What was this last part of the agreement in regards to?
get my name off of the car lease so that I'm not financially responsible. God forbid she gets in an accident.
No, you said this was the last piece. I'm asking what were the other pieces that you had to separate?
Objection, asked and answered.
Overruled.
You could answer.
Okay. Well, the fact that we had agreed upon everything else mutually.
What's everything else is my question.
What's that?
What's everything else is my question.
The fact that she and I agreed assets to split.
What other assets were there?
I would pay her. Okay. I would pay her for her share of the house. She would.
House. Did you pay that share of the house?
Yes, I did.
How much was that?
$200,000.
Okay, continue. What else was there that you had to separate?
That was it. Upon that, she would sign over the deed to me, and upon that, she would get my name off of the lease.
Did she sign over that deed to you?
Yes, she did.
Did you own furniture together?
Yes, we did.
Okay, where did you get that furniture from?
City Furniture.
Okay, and you took out, is it a credit card or a loan, or how did you buy the furniture?
Yeah, I co-signed.
Objection, relevance.
Overruled.
You could continue.
I co-signed a finance agreement for her when we were in the store.
Okay. Does City Furniture do a co-signer, or you both just signed on the furniture? Are you labeled as a co-signer? Let me rephrase.
Yes.
City Furniture, you're saying City Furniture has you listed as a co-signer, or you're just both on the loan?
She's the primary, I'm the secondary.
Okay, and you're saying that's how City Furniture does things?
As far as I know, that's the only time I've done business with them.
Okay. Now, what happened to all that furniture?
The furniture. I'm sorry, what was that?
What happened to the furniture you purchased? Where is it?
Okay. Okay. Well, when she moved out, I told her to take the furniture. She didn't want most of it, and she left half of it here.
Okay. Now, as of today, do you know if there's still a balance owed on this credit card?
From what I understand, yes.
Okay. When you split everything else up, did you guys agree to pay off this credit card?
No, there was no agreement between us.
Okay. So she left most of the furniture behind, but there was no agreement as to who was going to pay for it. Is that what you're stating?
I wouldn't say most of it. She took more than half. Okay, but I wouldn't say most. And no, it was because she was.
Let me stop a second. Let me back up. I believe you said she left most of it there. She didn't want it.
She didn't want it. She didn't like the color. She said it didn't fit in her apartment. She was going to buy new furniture.
Okay, so she did leave most of it behind.
No, she left 3 pieces behind. A couch.
And how many did she take?
She left the 3 pieces she left behind. Are still here.
And what are they?
Couch, a TV ensemble, and a patio table.
What other furniture was there?
She had a kitchen table with 4 chairs. She had a big armoire that she took. She took 3 bar stools. Off the top of my head, I can't remember anything else off the top of my head.
Okay.
There's 2. I'm sorry. There was a big armoire in the kitchen. There was a smaller armoire in the hallway. The kitchen table with 4 chairs, the 3 bar stools.
Okay. Do you know how much the original bill was for?
Let's say 5,000-6,000.
How many payments did you make towards that bill?
One payment I made, she reimbursed me for because it was her responsibility to make the payments. So if you want to count that, but
What made it her responsibility to make all the payments?
because she's the one that wanted to buy the furniture. She's the one that wanted to get the furniture, and I'm the one that said I'll co-sign as long as you make the payments. Therefore, it was her responsibility to make the payments for the furniture, just like it's her responsibility.
Yeah, that's sufficient. Just answer my questions, please.
I was.
So you had the items you had in common together were a house. And when I say together in common, things you owned that both of your names were on. There was the house, there was the furniture, and there was the car. Am I missing anything else?
That's it.
Okay. So you guys agreed to sell the house and split the proceeds and take care of the deed. And that was taken care of, correct?
Correct.
And you wrote up a contract as to the terms of how you were going to deal with the car, correct?
Yes, contract was written by her lawyer, Mr. Saad.
Okay. Why didn't you do anything with the furniture if your name was on that?
Well, because it was agreed upon between the defendant and I that she would take the furniture, and whatever furniture she left behind was her discretion, not mine, but that she would continue payments on the furniture until it was paid in full.
Do you know if she did that?
I don't believe so. I've never heard from City Furniture. So the last time, no, I haven't heard from City Furniture regarding any outstanding balance.
Okay. Now you said her attorney, what was his name? Saad you said?
Saad, it looks like S-A-A-D, Sam Saad.
And what was he retained for? Do you know?
Well, that was her attorney. I think she retained him for the part of the agreement where I pay her and she signs the deed.
Okay, but he wasn't retained for this hold harmless, correct?
What's that?
Objection, speculation.
Overruled. He can answer if he knows.
He wasn't retained for the hold harmless agreement, was he, by Ms. Giordano?
Yes, he was.
Okay, and what makes you believe that?
Oh, because she had her attorney write up this agreement. I suggested she have her attorney write up the agreement. She did. I read it. All the terms were in there that we agreed upon. I signed it and she signed it.
Is it true that you told her without this agreement you wouldn't release the money on the home to her?
Well, all right, kid. You want to know something? We had an
Mr. Pellegrino, just answer the question that was asked, please.
Oh, I'm sorry. Okay. Well, I'm sorry. What's the question?
The question was, in fact, didn't you state that if she did not enter into this agreement, you were not going to release the money on the house?
No.
Okay. All right, let's get to the agreement itself. When you leased the car, was it the intent of you and Ms. Giordano that she was going to be the primary driver of the car?
Correct.
Okay. Do you know if she's still driving that car as of today?
I have to believe she is.
Okay. Let's liken this to the City Furniture. You never heard from City Furniture, so you believe everything's okay. Is that correct?
I guess it's correct. Yes, I haven't heard anything negative.
So you assume it's okay?
Yes.
Okay. Have you heard anything from the car company?
No, I've not.
So you assume everything's okay, correct?
Yes.
Okay. Are you aware of any late payments whatsoever?
On the car?
Mm-hmm.
No, I'm not aware of the late payments on the car.
So you disappeared on us.
Oh, wait, somebody's trying to call. I'm sorry.
There you
I'm
are.
there.
Thank you.
Okay. So you have no knowledge of any late payments, correct?
Not on the car.
Okay. We'll get back to late payments on the furniture. What is the term of the refinance? When does it end? I'm sorry, the lease, I apologize.
The lease ends in July of 2021.
Okay, so about another month?
No, I'm sorry, 2022. 2022.
Okay, so you have basically 12 payments left.
Yeah, it's a 3-year, it was a 36-month lease. So yeah, about 12, 13 months, yes.
Okay, so to the best of your knowledge, Mr. Giordano's made 2 years of payments on time, as far as you know.
Correct.
Okay. Now, you entered into this agreement, paragraph 1, it was the hold harmless part. It basically says, if anything goes wrong as far as an accident, damages, anything of that nature, non-payment, she will basically hold you harmless and reimburse you for any and all damages, correct?
Correct.
Okay. Then you have term number 2 for refinancing of an automobile. Now, it says that she should refinance the automobile within 90 days.
Correct. Correct.
Okay. Now, do you know whether or not she tried to refinance the vehicle?
I remember reading her original answer to the court that she had attempted to last year, but I don't know what she's done since then.
Okay. Now, if she applied and tried to refinance the car and the lenders wouldn't let her, what does this agreement say to do thereafter?
Hand the car back to the dealership.
Is that what the agreement states?
Without reading it, Mr. Faden, I don't know if we got that far.
Do you want me to pull it back up?
Please do.
Okay. Bear with me one sec. This may or may not be the right document. Yep, there we go. All right, can you see it?
Yes.
All right, let's go through. Tell me when you're done with that page.
Well, let's not do that. Look, everybody's read this thing. It's 2 pages. What's the question?
My question was, if she's unable to refinance the car, does it state what the parties are supposed to do in that instance? And he said he doesn't
I will
know.
note it does not address that instance.
Okay.
I'm with you. There's no jury here.
Okay, I'm just making sure because he said he didn't remember. Okay. Now, do you know, hypothetically, you said you'd like it returned to the dealership. Do you know if the dealership will take it back?
Objection calls for speculation.
He can answer if he knows whether the dealership will take it back. If he does not know, then he needs to simply stick to what he knows. Mr. Pellegrino, do you know the answer to that question?
Your Honor, a dealership will always take a car back early.
And how do you know that?
I worked in the car business.
Okay. And being that you worked in the car business, what happens if a lease is returned early?
If a lease is returned early, then it's
Objection, this is calls for speculation.
Oh no, I'm enjoying this. Go ahead, Mr. Pellegrino. Tell us what happens when you turn in a car early on a lease and break the contract.
Oh, what happens is that you're responsible for the balance.
There you go. Yeah,
Okay.
Come on, guys. There's no jury here.
You're responsible
Let's be
for the
straight
balance,
with each other.
and you take a hit on your credit.
Yes, you do.
Okay. So you'd rather take a hit on your credit and be responsible to pay back this lease than for Mr. Giordano to comply with the contract with the dealership and pay the terms as they are. Is that correct?
If I have a choice between taking a hit on my credit or having a bullseye on my back every day that I could be named as an additional defendant in a vehicular lawsuit, I'll take the hit on my credit.
Okay. So what you're saying is the hold harmless paragraph in paragraph number 1, you're saying you don't believe that means anything and that won't help you. Is that correct?
I don't understand the question.
You have a hold harmless paragraph which states if anything happens that she is to defend you, to pay whatever there is, and basically hold you harmless for any damages whatsoever. For any negligence, I'll read it to you. For any acts, omissions, negligence, or willful misconduct on the part of Tracy. And that includes penalties, fines, judgments, awards, decrees, attorney's fees, related costs, or expenses.
That's
So
all under
paragraph 1. Are you saying you don't feel that's protecting you?
No, no, Mr. Faden, I don't, because I could be still brought up regardless. If an attorney sees that I am attached to that car, there's no reason in the world why he wouldn't come after me as well. And I don't believe I have to defend myself, or I don't think I should have to defend myself for anything that she causes while my name is still on that lease.
Okay. Do you know whether or not the car is insured?
I hope so.
It's required under a lease from a dealership, correct?
Correct.
And you've got to show that to the dealership, correct?
Mr. Faden, I don't have nothing to do with the car any longer. Okay, I haven't seen the car since she left.
You work for a car, it's not what I'm asking you, sir. You work for a car dealership. I'm saying you have to prove insurance before the car gives you a leased car, correct?
Objection argumentative.
Overruled.
Of course you do. Yes, you
There
do
you
have to
go.
show insurance. Yes.
Okay, so as far as you know then, based on your knowledge of car dealerships, Ms. Giordano has insurance on the car, correct?
I hope so.
Okay, so assuming she has insurance and you've got a hold harmless clause where on the part of Tracy, she has to basically defend you or pay any damages on your behalf and hold you harmless from any damages. What exactly are you concerned about?
Well, the fact that she couldn't refinance the car to get my name off the lease tells me that she's not financially strong enough to protect me if there's a lawsuit against the both of us.
Okay, so you know she can't afford to refinance it, correct?
Well, not necessarily. She had her
That's
opportunity.
what you just said.
What's that?
That's what you just said.
What?
That she can't afford to defend you because she can't afford to refinance the car.
Well, if she would have refinanced the car, we wouldn't be in this situation today.
That's not my question.
Oh,
You're aware that she can't refinance the car, correct?
no, I'm not aware. It seems that, that I haven't had any communication, or she hasn't given me any updates on trying to refinance the car. But I don't know if she's able, because she owns her house outright. Why hasn't she refinanced to her house?
I didn't ask you all that, but thank you. How have you been damaged?
How have I been damaged?
Yes. Have you paid any money out of pocket? Has anybody sued you?
Well, so far, the only money out of pocket, is the mediation that we've been through.
No, outside of the lawsuit. No, sorry, outside of this lawsuit. Have you paid any money to anything outside of this lawsuit?
No financial responsibility outside this lawsuit.
Okay. Have you been sued on this lawsuit?
Not yet.
Okay. So what exactly are your damages here besides your legal fees?
Objection calls for a legal conclusion.
Overruled.
Overrule means I answer, Your Honor.
And was that
Correct.
Mr. Zermay?
I'm sorry?
Mr. Zermay does not have a speaking part on this witness.
Apologies, Your Honor.
Okay.
Mr. Faden, repeat the question, please.
Outside of your legal fees, what are your damages?
That damages the anxiety I live with every day, worrying about being brought into a lawsuit. That's my damage.
Okay. Let me ask you one last time. In regards to paragraph 1, the hold harmless clause, why did you put that there?
Well, I didn't
Why
put
did
it. I'm sorry, what's that?
Why did you agree to the hold harmless clause if you didn't think it was going to help you at all?
Well, listen, first of all, her attorney drew it up. I read it and agreed, but it still doesn't mean I don't have a law degree, but I have a master's degree. And I have to believe from everything I've ever heard that in any lawsuit, everybody that can be found to help pay or be accountable will be. So that's why this goes above and beyond what term number 1 says.
Okay. So you're just guessing someday you may have a problem.
Listen, I'm
Just a clear question. You're just speculating that someday you might have a problem.
Yes, and I'm trying to avoid that. Yes.
Okay. Now, I've read through this contract many, many times. Ms. Giordano was required to refinance this car and try to remove your name from it. What were you required to do under the terms of this contract?
What was I responsible for under the terms of this contract?
Were you responsible for anything?
You know what, Mr. Faden? Again, I'm not an attorney, but I think the only thing this was based on was just her getting my name off of the lease and us ending our relationship mutually.
Okay, the relationship was over before this was signed, correct?
Yeah, it was heading that way. Absolutely. This was the final nail.
But you were broken up the day this was signed, correct? You weren't together in a relationship anymore. You decided you were broken up, correct?
No, not necessarily. Not necessarily. We were still living together, so I consider us being officially broken up the day she walked out of the house.
Okay, so you're trying to say the date you signed this agreement, you were still boyfriend and girlfriend?
We were still
Objection,
living together.
relevance.
Yeah, it's sustained. This isn't relevant to me.
Well, Your Honor, a little latitude. I'm getting to the point where if they were still boyfriend and girlfriend, why would he make her enter into this? And if they weren't, he should have known the terms. And I'm trying to figure out what he was doing as consideration for this agreement.
Well, let me save you some trouble. I understood his answer to be there was no consideration, so we can move on from that point.
Okay.
That was apparent on the face of the contract, by the way.
Thank you. Okay, a couple last questions. So the day you entered into this agreement on, it looks like May 12th, 2020, that's correct, right?
No. We entered into this agreement February 11th, 2020.
Oh, I'm sorry, there's a date next to the paragraph 2 where it says 5/12/20. I'm not sure what that is.
That's the deadline. It's February 12th at the top.
Yes.
Okay, I understand now. So on February 11, 2020, when you entered into this agreement, did you think Ms. Giordano had the money and finances to refinance the car?
I'm sorry, what was that? What about finance?
On February 11, 2020, did you and Ms. Giordano both understand that you both thought and assumed she'd be able to refinance this car, correct?
Correct.
Okay. At that point in time, did either of you check with any banks or dealers on February 11, 2020 that was even possible?
Well, I can only answer that
It's
question.
a yes or no question. Did you check with any lenders or dealerships as to whether or not it was possible for Tracy to refinance the car on execution of the agreement? Yes or no?
No, that was responsibility.
Okay. You assumed she could, though, correct?
Of course.
And again, if she was denied, what was she supposed to do?
She was denied. What was she supposed to do? Well, Mr. Faden, she owns her house outright, which is worth about $175,000, $180,000.
I'm not asking about her house. I'm asking about the car. What did you intend her to do if she got denied on the refinance?
I had no idea she would be refinanced because she owned an asset outright. I had no idea she would not be able to refinance.
My question, sir. If she got denied from the refinance, what did you expect her to do?
Objection calls for speculation.
I'm gonna sustain the objection on other grounds. It's not relevant. The contract doesn't address that, and what Mr. Pellegrino may or may not have thought really isn't relevant.
Well, for mistake of fact, it is kind of relevant, Your Honor.
Well, I think you've already established that with prior questioning.
Okay. I have nothing further then, Your Honor.
All right, any redirect?
Yes, Your Honor. Mr. Pellegrino, I want to direct your attention to term 2 of the contract, if you have that in front of you. And in fact, I will do a share screen again on that.
I have it.
Oh, perfect. In that, do you see where it says Paul shall cooperate in the execution of any documents required to remove Paul's name from the title?
Yes.
So Is it fair to say that that was a promise that you were making in exchange for her getting your name off of the title, or excuse me, off the vehicle lease?
Correct.
And again, I want to ask, just to make sure that this is clear, you weren't the one who drafted this agreement, correct?
No, I was not.
That was Ms. Giordano's attorney, correct?
That was Ms. Giordano's attorney that drew up this agreement.
I have nothing further, Your Honor.
Okay. All right. Plaintiff can call their next witness, please.
Your Honor, we'll call Ms. Giordano.
Okay. And Ms. Giordano, if you want to raise your right hand, the clerk will swear you in.
Do you swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You may proceed.
Thank you, Your Honor. Good morning, Ms. Giordano. How are you today?
Wonderful. Thank you.
Ms. Giordano, what do you do for a living?
I work for the Collier County Clerk of the Circuit Court.
And what do you remember about this case?
Remember about this case?
Yes, ma'am.
That's not a good question.
Yeah.
I apologize.
Ask specific questions.
Okay.
I know you did that on the first witness, but let's ask a specific question of the witness so we don't get a narrative response that's objectionable.
I want to draw your attention to the contract that's been previously admitted into evidence as Plaintiff's A. And again, Ms. Giordano, are you familiar with that contract?
The hold harmless agreement?
Yes, ma'am.
Yes, I am familiar with it.
And did you hire an attorney to draft that for you?
My closing attorney for my condo drew it up because the plaintiff wasn't going to release my funds for me to purchase the condo unless I gave him that document. It was a requirement for me to get my money.
And is that your signature on the contract?
It is.
Okay. And is it your understanding from the contract that you had 90 days to refinance an automobile?
That is my understanding.
Okay. And did you do so?
I attempted to. I contacted 7 or 8 different institutions, and also COVID-19 hit, so the banks all changed their requirements for lending, but I was denied on every request. I believe I've attached them as exhibits, all the lenders.
So you were not able to get financing at all, correct?
That is correct.
Do you have any assets?
I don't understand the question. How is that relevant?
That's a pretty simple question. Do you
actually
have
my
any
problem.
assets?
I
Like
own my
houses?
home. I
You own
own
your
my
own-
home. Yes,
Okay, you own your home outright.
that's correct.
And why weren't you able to obtain financing through your home?
Because I wasn't in the property long enough, and because my credit rating isn't a 750 or better, and because the lending institutions all changed their requirements when COVID-19 hit.
Okay, I have no further questions.
Okay, Cross. Mr. Faden, are you still with us?
I'm sorry, I didn't realize I still have my stuff blocked. No, I'll save it for my direct examination, Your Honor. I won't go across.
Okay. All right, plaintiff, call your next witness.
Nothing. We have nothing further.
Plaintiff rests.
Yes, Your Honor.
Okay, what says the defense?
I'd like to move for a directed verdict. They failed to prove their case in regards to count number 2. They've proven that there's financial relief and contract relief available, so they're not entitled to equitable relief. In regards to count number 1, I think they've clearly proven, and between the 2 witnesses that have testified, that there was a mistake of fact, that they assumed the date of the agreement that Ms. Giordano could refinance. She did everything possible to refinance, and being that she was denied in every which way, including on the home, any money out of the home, that it was impossible for her to refinance. Further, the plaintiff has testified, other than his legal fees, he had no damages. He's speculating that some random time in the future there may be damages, and therefore this case must be counts 1 and 2 must be dismissed.
All right. Response, plaintiff.
Yes, Your Honor. If I may briefly be heard regarding this issue, as the Supreme Court made it clear in one of their cases I cited earlier, it was not Spokio. Yes, it was Spokio Inc. versus Robbins. Risk of harm is damages that's contemplatable under a contract. That's just black letter case law articulated by the Supreme Court. There is risk here. Ms. Giordano's continued operation, the vehicle exposes Mr. Giordano to continued liability stemming from her intentional torts. She's testified that she doesn't have any assets to buttress it. And indeed, despite Mr. Faden's citation to insurance, there are exceptions to insurance. And indeed, in Florida, when there's PIP, an exception to the PIP statute that isolates people from liability stemming from accidents, that's just merely as a result of the accident. If there's substantial bodily harm, then that sort of opens everybody up to liability under the statute. So there is substantial risk for that Mr. Giordano is exposed to for Ms. Giordano's continued use of the vehicle. And indeed, we've demonstrated that this car is special and unique to the parties. It was a result of their horrifically failed relationship. It's uniquely horrible to these two parties. And as a result of that, it's properly subject of specific performance. And even if it's not subject to specific performance, there's monetary damages that Mr. Pellegrino be entitled to avail himself of this contractual benefit. There's a payoff value here. And indeed, Ms. Giordano can be, just simply turn the vehicle and pay off the damages, as Mr. Pellegrino testified to. So as to that, counts 1 and 2 should be sustained. And I believe Mr. Faden has the burden to demonstrate that there's the impossibility defense. They haven't demonstrated that it was impossible. She merely said that she went to 8 different lenders. Did she go to the bank at Shinhan Bank in Korea? Did she go to the Bank of China? Did she ask her, anybody for a loan? She didn't ask me for a loan, for example. I don't believe he asked Mr. Brinsky for a loan. Didn't ask, Josh Valletta, bless his heart, for sitting through this, for a loan. She didn't exhaust all of the possibilities for getting a loan. She has a house that she could refinance to go ahead and accomplish this. Sure, it may be inconvenient for her to go ahead and get a mortgage, but inconvenience or even infeasibility does not constitute impossibility in the state of Florida. And they haven't proved it. There's no affirmative defenses here. And we've satisfied all the elements chosen to say binding contract. Ms. Giordano materially breached that contract, and Mr. Pellegrino is damaged. And for that reason, a directed verdict at this point is inappropriate.
Let me ask you, Mr. Zermay, you kind of blew past this. Do you have a contract?
Yes, Your Honor, there is a contract.
What are the elements of a contract? You want to ask your law student?
Yes, that there is an agreement between the parties, which we have here. There's 2 signatures on the agreement. There's assent to those agreements in terms.
Offer?
Yes, offer, acceptance.
And? Ask your law student, unmute, sir. Tell us what's the 3rd element of a contract. You get it in the first 4 months of law school.
Consideration.
There we go. Do we have a contract here?
Yes, there is mutually binding consideration. There are mutually exchanged promises here. Mr. Pellegrino has agreed
Your Honor,
hold on, Mr. Faden. Hold on. Don't interrupt. I'll give you a chance to respond. Mr. Zermay, go ahead.
Yes, in term 2 of the agreement, and as Mr. Pellegrino has inexplicably testified to, he has the duty under the contract to cooperate in the execution of any documents required to remove Paul's name from the title. That is a duty, and effectively it's, relinquishing the car to Miss Giordano. This is mutually binding consideration. If you do this, if Miss Giordano does this, then Paul agrees to do that. There is mutually binding consideration here, and that's just plain from the face of the agreement.
All right. I'm going to grant the involuntary dismissal. I believe that's the appropriate term at this point of counts 1 and 2 of plaintiff's complaint. There is no contract here. There is no consideration. You can point to Mr. Pellegrino has to sign documents. That's not consideration. There is no contract here, and so count 1 for the breach of same and count 2 for a declaration regarding same must fail as a matter of law. I'm granting defense involuntary dismissal as to counts 1 and 2. Mr. Faden, the defense case on the counterclaim, please.
One moment, Your Honor. I would like to call Ms. Giordano.
All right, she's still under oath. Go ahead.
Ms. Giordano, you have a counterclaim in this suit for breach of your agreement in regards to city furniture.
Yes.
Do you recall buying furniture?
Yes.
Okay, and how did that come about?
He didn't want to move most of the furniture. It was cheaper to buy furniture when we got down here. So
No, I'm sorry, Ms. Giordano, back up.
Objection leading.
Ms.
He
Giordano,
hasn't
can you
really
hear me
gotten a
good?
question out. So hang on just one second. So Mr. Zermay, this is going to be your witness.
Yes, Your Honor.
Okay. Mr. Faden, let me let you start that over because the Zoom hiccuped a little bit.
Rose.
Yeah, it's still a little fuzzy on my end. Can you hear me good, Ms. Giordano?
Yes, now I can.
Okay, let me back up. My question is, how and when did you acquire the furniture?
The second day we got down here to Florida, we went to City Furniture and bought furniture. We purchased the house June 28th.
No, Ms. Giordano, please just answer my questions. You can't just go on a narrative.
I'm sorry.
Okay, who is we?
Paul Pellegrino and I.
Okay, and you went to purchase furniture together, correct?
That's
Objection
correct.
leading.
Sustained. You need to not ask leading questions at this juncture.
Understood, Your Honor. Who went to buy furniture?
Myself and Paul went to City Furniture and picked out and purchased the furniture.
Okay, what furniture did you purchase? Can you be more specific?
We purchased a couch and a chair to match it, an end table, a 4-piece gigantic 9-foot wall unit, a desk for his daughter, a patio table and 6 chairs, a credenza and a hutch, and a dining room table and 4 chairs and 3 bar stools.
Okay, and how much did you pay for that?
It came to about $7,000.
Okay, and how was that paid for?
We were paying, each of us were paying $354 a month.
But I'm sorry, back up. But how was it paid for? Did you pay for it?
Oh, we
cash,
obtained a
on
loan. We obtained a loan.
Okay, and it was for approximately $7,000?
Yes.
Okay, and what happened next?
Well,
Did you get a bill?
yes, we have bills. Yes.
Okay, and who paid those bills, if anyone?
We had it set up so that it would automatically debit our joint checking account.
Okay, and at some point in time, was that account ever separated, or is it still a joint? Is there still a joint account somewhere?
No, he withdrew all the funds out of that account.
Okay, do you know approximately when?
I would have to say September, before he even moved here.
Okay.
No, I'm sorry, that's incorrect. Yeah, yes, September
Of what year?
2020.
Okay, and once that account there was no more funds in there, how were payments made?
I was giving him a check every month. I don't know how he was paying it. I have copies of the checks that I wrote him.
And how much was the monthly payment?
We were doubling up so that we could pay it off before the interest. It was interest-free for a year if we paid it off within a year. So we were paying about $700 a month, $354 each.
$354, you said?
Each, correct.
And how long did that go on for?
Just a couple of months. We got the furniture in August, August. He moved in October, and we were breaking up by December.
Okay, and what happened to the payments on the furniture then?
He stopped paying them when I moved out.
Okay, was he supposed to pay them?
Of course, he's supposed to pay them. He has the furniture and he's on the loan.
Okay, now you heard earlier his testimony that he thought he was a co-signer. What is your understanding of how City Furniture does that? Was he a co-signer?
No, we were both on the loan, equal debtors.
Okay. And who has all the furniture now?
He has most of it. It was
What do you
purchased
have?
for a large house. I took the dining room table and 4 chairs. I took the hutch and I took a credenza. And I have 2 of the bar stools, not 3, and only because he made me take them. They weren't purchased for this house. They don't fit in this house, but he made me take them.
Okay. Was there any sort of agreement on who was going to pay what after the breakup?
Yes, we were each going to pay for that furniture that we kept.
Okay. And there was approximately 50-50, or did you keep less than half of it?
No, I kept much less than half of it. And I continued to pay the loan, just the minimum amount due even after I left the house with him, just to keep it from hitting my credit so that I could obtain the funding for the car.
Okay. So you paid the minimum amount due. How much was that?
It was about $163 a month.
And when did you start paying that, and when did you stop, if you stopped?
I stopped, the last payment I made was $321 for the June 12th payment, because I knew that in July, if he didn't pay the entire loan off, then they were going to hit us with the interest going back to when we initiated the loan. I didn't have $3,000 to pay off his debt, so I did not pay a payment in July. He has not paid since January of 2020 anything for that furniture.
Okay. And what is the current bill outstanding? Do you know?
City Furniture just sent me a statement that it's $5,335.82.
And that's what's left now?
It's been charged off, and the plaintiff did attempt to make a payoff settlement of $25,83.55, and he defaulted on that as well.
Okay. So how much money did you pay from the date he stopped paying through now?
I'm going to object as to this was not disclosed in discovery. We asked this question in discovery, and it was, again, not properly disclosed, and this would be the impermissible trial by surprise that the court has assured the plaintiff wouldn't happen.
All of this was in my cross motion.
Mr. Giordano, wait for the judge.
Mr. Faden, can you address that concern and point me to where, and actually let me ask Mr. Zermay to be specific as to the discovery piece that requested it. So Mr. Faden can look and assure us that he has adequately answered that accordingly. What are we looking at? Is it an interrogatory or request to produce?
Yes, it is a interrogatory. And the request for admissions. It's, again,
Your Honor, request for admissions was already ruled upon.
Hang on. We still don't even know what we're talking about. So I'm going to ask Mr. Zermay, give me a date. My judicial software does not have docket numbers, so the date on which the discovery was put in the court file and propounded, and then I'm going to let Mr. Faden tell me if he has properly responded and how so I can rule on the objection. But let's make sure I know what you're even talking about first.
Yes, Your Honor. One of the interrogatories is interrogatory number 19. Is your response to each request for admission served with these interrogatories an unqualified admission? If not, for each response, it is not an unqualified admission. State the number of the request, state all facts upon which you base your response, state the names, addresses, and telephone numbers of all persons who have knowledge of those facts, and identify all documents and other tangible things that support your responses, and state the name, address, and telephone number of each person that has that each document or thing.
Let me go back. I need you to tell me what document you're reading from, because I'm not there with you. When did you propound this?
I propounded these interrogatories or these requests for admissions on the 12th day of December of 2020.
Okay. And this was the substance of a prior skirmish because Mr. Faden said he didn't get them. And then upon reading your summary judgment, he immediately answered them and sought relief from technical admissions. And I ruled in Mr. Faden's favor on that. But
Your Honor, I can save the court some time here. I'm not asking anything about what Tracy has done or not done. I am asking Tracy to testify as to what she is paid versus what he is paid. And I've not tried to enter any evidence into record right now.
Well, my notes, my unfinished sentence in my notes, because I'm quite merely a stenographer here, she paid blank. She was getting ready to tell us everything she had paid. And I'm understanding Mr. Zermay to be saying, we asked her to outline exactly what she paid and we didn't get a response.
I'd like to see that because I don't recall that.
Okay.
In response to the interrogatory, he said, what evidence are we going to use? And we said the city furniture statements. We were very clear. And if he wanted those statements, he could have asked for them in a separate request to produce. He did not.
And Your Honor, if I may briefly, if he identified those statements, we would have an opportunity to ask for them.
There's one set of city furniture statements.
And if I could please finish my remarks, I'd be.
Yeah, let's try not to interrupt.
And I apologize.
Yes, and moreover, I guess this would also qualify as the testimony that it was formerly unidentified that was referenced in all of the interrogatories. Again, this is a trial by surprise. They had more than an opportunity to outline in writing under oath what they intended to put before the tribunal at this stage. For whatever reason, they chose not to, in direct violation of a court order that was very unambiguous. And the court at the hearing on the motion for order to show cause stated that these answers would be excluded, and we respectfully request that that be the case at this stage.
And so specifically, Mr. Zermay, you're indicating that they never itemized, that you made a specific request, tell me exactly what you have paid, and they did not respond to that with any specificity, and so she should be prevented at this point from telling us specifically what she's paid. Yes,
Your Honor. In particular, I believe if we want to look to the interrogatories, it's actually interrogatories 1 through 14. We asked about every single one of their paragraphs regarding damages that they alleged in the counterclaim, and it was bare. And I believe the court even said that these interrogatories were wildly insufficient. We asked about all these damages, and again, it was very bare. And we are being subjected to a trial by ambush, trial by surprise at this moment.
Okay.
Your Honor, if I may respond, I would like to see chapter and verse. The requests were very generic in nature. They stated, what evidence did you wish to provide? And I was very specific. The testimony of the parties, which would be Tracy Giordano and Paul Pellegrino, and the city furniture statements. There's one city furniture account. It was referred to in the counterclaim. It's outlined in the counterclaim. This isn't a surprise. This is my whole counterclaim, is there was a city furniture, there was furniture bought, there's a city furniture bill. Mr. Pellegrino didn't pay his half. There's no surprise here. There's no ambush here. This is the crux of the complaint.
Mr. Faden, did you produce those statements?
I absolutely did not, because there was never a request to produce propounded. And I did not, and I did, Tracy, wait.
Hang on. Mr. Faden speaking.
We, in regards to other documents, yes, we have submitted to them, but there wasn't a specific request to produce those statements at any time throughout this case. He could go through the whole docket and try to find one. And as far as evidence, I'm not proposing to introduce those right now. He could object if I try to introduce them.
Well, my point was, if you had produced them, he might not be able credibly to claim surprise.
But he never asked for them.
All right, but he asked for all evidence in support of each one of your paragraphs of your counterclaim, and the response was testimony, or was it testimony and the August 3rd statement from City Furniture?
It was testimony of the parties and the City Furniture statements. And again, Your Honor, this is interrogatories. We don't have to produce documentation in an interrogatory. He knows how to practice well enough where he knows if he wants documents, it's a request to produce is the proper tool to get them. If he wanted those, he could have said, please produce all of the City Furniture statements. Not to mention his client is admitted already, he's on the account and that it exists. So his client has access to these as well. If he needed them.
It doesn't say City Furniture, it says statements and testimony.
In which, it depends on which interrogatory request.
Well, I'm looking at, because the interrogatories weren't filed, so I don't have those. I have the response to interrogatories, May 6, 2021.
Let me just pull that up 1 second, Your Honor. May 6, 2021.
That's your response.
Which number are you on? I'm pulling it up now.
Again, I don't have the interrogatory. I just got the answers.
Your Honor, if you look at number 17, it's very well outlined. The dining glass set, 4 dining chairs, curio cabinet. I mean, this is all outlined here.
And Your Honor, if I may briefly.
I'm sorry, I wasn't done, Mr. Zerme. And number 18, loan applications and city furniture statements.
Okay.
Not to mention, we outlined some of the costs here in response to his question. I don't have the questions in front of me. He needs to pull those up. But I mean, we specifically said the city furniture statements. There's only one set of city furniture statements.
Okay. Let me go back to Mr. Zerme. And Mr. Zerme, did you ever do a request to produce?
Your Honor, we didn't have time to do a request to produce. Again, if the court remembers, they only answered these interrogatories after we filed a motion for an order to show cause. A trial was less than a month away, and the court did state that it would exclude all evidence that was not properly disclosed as a result of defendants, malfeasance or negligence or what have you. There's, again, this is another trial. This is a trial by surprise. We don't have those documents. They weren't properly identified. It's been incredibly generic, and it's even for interrogatory number 17. State every fact, identify every document, person that supports your affirmative defense. They didn't identify every document. If there's statements, that's a plural. And you'd think excuse me, any such specificity, like the city furniture statement of whatever date, the city furniture statement of this date, stating, what have you. They didn't identify those documents, and for those reasons, testimony regarding them and attempting to bootstrap their testimony regarding it is wildly inappropriate and prejudicial to the plaintiff.
Okay. Objections overruled. This is not a tennis match. You do not have to wait for their response to one form of discovery in order to seek another form. Request to produce was an obvious move the minute you got the counterclaim. It would have gone along nicely with this. You chose not to bring it. The fact that you got up against a trial date is a lack of diligence on your part. Their answers are sufficiently specific to let you know what they were going to rely upon. I note as well that it would be quite likely that all of this information is equally available to Mr. Pellegrino. He's on the loan. And so this is not prejudicial in the slightest. I'll allow the question. Objections overruled. Mr. Faden, you may continue.
Okay, let me just back up a drop. Mr. Giordano, do you know what month again that the additional interest was all charged back?
July of 2020.
Okay, in July of 2020, what was, with the interest added to it, what was the statement balance at that time? Do you have any clue?
The balance before the interest was about $3,000, and it is outlined in my April 30th certified letter to Mr. Pellegrino with a spreadsheet.
I know, but I didn't ask that yet. So
okay.
It's $3,000 before the interest, and then in July, the interest accrued, and what was the bill then?
So the balance was $3491.80 when I sent him a certified letter, and now it's been charged off, and the balance is $5,335.82.
Okay, and did Mr. Pellegrino pay any of that?
No.
I don't have anything further, Your Honor.
Okay, cross-examination.
Yes, Ms. Giordano. My name is Zachary Zerme. I'm attorney for plaintiff. I have a brief question regarding the purported agreement between you and Mr. Giordano. Is it in writing?
Mr. Pellegrino is a signer on the account.
Excuse me, if you may please just answer the question. Is there an agreement in writing between you and Mr. Pellegrino for him to pay for your city furniture debt? Yes or no?
It's his debt as well, and when he signed on the loan.
Stop, guys. Stop, guys.
I'm objecting to the form of the question, Your
It's
Honor.
a rhetorical question. I get it. There's no written agreement. The court's going to have to determine whether this is a shared debt or whether this debt belongs to one person or another. Let's stay away from rhetorical questions, okay? I know there is no written agreement where they agreed to pay X or Y.
Yes.
That's really an uncontested fact, isn't it? Why are we fighting? Okay, keep going.
Yes. Was any of the furniture that was purportedly purchased that you purchased appraised?
I didn't have mine appraised. I can't tell you what he did.
I'm gonna object this to relevance. The appraised value
Sustained. It's not relevant. Next.
Your Honor, if I may be briefly heard, it does go to the value of the furniture. I believe that there's two different claims here. There's one for a breach of contract, which I don't need to explain to the court that we're going that any purported contract between the parties is unenforceable as a matter of law as under the statute of frauds. But as to their unjust enrichment claim, it goes to how much damages that she would be entitled to. And under Florida law, there needs to be particular damages, and that's where I'm going with the appraisal. She
didn't appraise hers, so she may have a damages problem. But go ahead.
Yes. So, Ms. Giordano, you don't know how much the furniture is worth at the current time, do you?
Your Honor, I'm going to wait, Mr. Giordano. I'm going to object again as to relevance. The appraised value doesn't matter. The damages are the monies that are due to city furniture. She's not claiming damages as to the furniture she doesn't physically have in her possession. The bill to city furniture doesn't change regardless of if the furniture is worth $1 now or $10,000 now. That's irrelevant to whether or not the city furniture bill is what needs to be paid.
And Your Honor, that would be relevant in and of itself if city furniture was a party to this lawsuit. They're not a party to the lawsuit. If city furniture wanted to step in and jointly sue Mr. Pellegrino and Ms. Giordano regarding it, then they would have standing to assert those damages. At this stage, it's not necessarily relevant. It's not Ms.
And the circle is complete.
Yeah, and the circle is complete.
I don't see any relevance to the value of the furniture, but I'm very familiar with the no interest for X number of months agreements. And the second the interest kicks in, I will be willing to take judicial notice of the fact that the furniture is definitely worth less than is owed. That's how those contracts work. But whether either of these parties owes each other anything remains very much to be seen. The value of the furniture, I don't believe to be relevant, but I guess it's less than $5,300 at this point. We're upside down on the furniture. That's how that goes. Upside down on the car too.
Just for the record, to put competent substantial evidence, for any subsequent proceedings, if any, are necessary. So to recap, there's no agreement in writing, right?
Are you arguing or questioning?
Questioning.
Okay. I think that one's asked and answered. She said no.
Yeah.
They do not have an agreement in writing between them as to how they would handle city furniture's debt.
Okay. And I think that's plaintiff's cross of Ms.
Okay.
Giordano.
Any redirect from Ms. Giordano?
Not at this time.
All right, call your next witness.
I'll rest, Your Honor.
Okay. All right, what says plaintiff?
Plaintiff requests a directed verdict as to count 1 and count 2 of the counterclaim. Again, there is no signed written agreement purporting related to any city furniture debt. This is Ms. Giordano's debt, not Mr. Pellegrino's debt. It's plainly barred by statute of frauds, has been argued ad nauseum from the beginning of this case, including the motion for summary judgment, and we're going to again raise that ground. And as to unjust enrichment, again, there is no specific ascertainable damages that Ms. Giordano has, and there's just simply nothing there. And that's as to plaintiff's argument for why a directed verdict is appropriate as to counts 1 and 2.
Okay, Mr. Faden, let me ask you to respond, and if you'll respond specifically count by count, please, for the court.
Well, first of all, Ms. Giordano's testimony was uncontroverted and therefore stands. Period. There was it was totally uncontroverted. The defendant made no case as to it not being true. Further, the plaintiff counter defendant testified that he was the co-signer on the furniture. He testified part of it remains in his house, and he testified the bill is there. The amounts, Ms. Giordano was very, very clear on. The amounts is $5,335.82, and that went uncontroverted. As far as the statute of frauds, he's misinterpreting the law. The statute of frauds applies to the purchase of goods. This is not an agreement to the purchase of the goods. The goods were purchased the day they went into the store and entered into that credit card. What Mr. Giordano is asking for him to pay part of the bill. That is not for the purchase of the goods. The goods were already done and purchased. This has nothing to do with that. This is an outstanding credit card with a company. It could be for anything. And the statute of frauds is not applicable here. Number one, for that reason. Number two, this could have been taken care of in less than a year.
Let me ask you, I'm going to have the same questions I had for Mr. Zermay in plaintiff's case in chief. And I want to make sure I'm looking at the right document. October 7, 20, no, that's answer 2 counterclaim. Where is answer and counterclaim? That was done pro se, wasn't it? 6/25/20?
6/25/20.
I don't believe you've ever amended that when you came onto the case later, Mr. Faden, but I think the answer and the counterclaim were filed pro se. Do I have that right? Am I looking at the most recent iteration of defendant's counterclaim?
If you could give me 1 minute to answer that, because I got logged out again.
Okay, no worries.
The site only leaves me in for so long.
And I'm looking at, it was a 55-page answer and counterclaim. And my screen is very small, so I'm trying to make sure I know where the answer ends and the counterclaim begins. I'm not sure that it's evident. I think they're a blended document.
Here, let me check. Sorry, it's opening up. It's taking a while.
I guess it's paragraph 6. I think we're looking at paragraph 6, essentially trying to be a breach of contract claim.
No, it looks like, I don't know how they labeled it in the docket, but it looks
They're
like
not.
I did redo this. I did file an amended answer, counterclaim, motion to dismiss. I don't know how they labeled it though. I'm trying to find it in the docket.
Okay. Well, there's plaintiff's motion to dismiss defendant's pleading.
I believe they incorrectly labeled it, and that's why I'm having trouble finding it.
All right, it's 10/7/20. I was right the first time. That is, and again, you label it.
That is
Let me make clear for the clerk's benefit, you label it when you file it. So this says answer to counterclaim by Tracy Giordano, but it's actually answer affirmative defense's counterclaim and motion to dismiss. So that'll be our operative document for purposes of the motion for directed verdict. I don't think there were any subsequent iterations, but again, correct me if I'm wrong.
No, I think that's the last one.
Okay, good. So this is at least much more clear.
Yeah, I kind of did clear and concise. In regards to breach of contract count 1, I specifically stated the breach of the contract was paying the debt, not for the furniture, and therefore the statute of frauds is inapplicable.
Okay, hang on, slow down, because I'm trying to catch up to you. I want to be very specific.
And Your Honor, if I may just briefly speak, the operative documents at this stage don't necessarily matter. What matters is competent substantial evidence for the tribunal. Mr. Faden could write anything he wanted in his counterclaim. He could write, that the furniture was actually purchased entirely by Mr. Pellegrino. That is not competent substantial evidence for the tribunal. And
this isn't helpful, Mr. Germain. I am entertaining. Don't snatch defeat from the jaws of victory. I'm entertaining your motion.
Thank you.
But I have to figure out exactly what it is that the operative document promised to prove here, so that I can figure out if, in fact, there is competent substantial evidence. So bear with me for a second while I catch up. So I'm up to page 4, and all of that, top of page 4 is still answer. Then there are affirmative defenses, and I'm still looking for counterclaim. Then there is a motion to dismiss, motion to dismiss. I'm up to page 7. Okay, bottom of 7 is our counterclaim. And that is really basically starts on page 8. So the allegation, count 1, breach of contract, count 2, unjust enrichment. That is what the motion for directed verdict or involuntary dismissal is directed toward. So I just wanted to go back then, Mr. Faden, and I want to have you articulate what is the contract. This is important. You're alleging a breach of contract. What is the contract you allege was breached?
The parties had purchased furniture together and they agreed between each other to both pay. And that's why they both signed on that agreement. The plaintiff counter-defendant failed to pay anything on that card, which he testified to that he was a co-signer on. He also testified to that he retains the furniture. He also testified he made one payment on it. That was his testimony.
Okay. And so,
My clients,
again, this is a very technical question. I'm going to be very specific.
Mhm.
What you're alleging is not a breach of the city furniture contract, but you are
Correct.
alleging a breach of an oral contract that stemmed from the city furniture contract.
Correct. And my client testified uncontroverted. The plaintiff counter-defendant did not testify anything contradictory. She testified that they purchased it and they agreed to pay the bill together.
Well,
He
Mr.
failed to do
Pellegrino
so.
testified very differently in the first half of this trial. He did speak to that it's her furniture, she's paying for it, and when she left the relationship, she abandoned certain furniture. That's his testimony. I'm not saying that that's gospel truth, but there is, that is a point in controversy.
As far as the testimony and the counterclaim, they presented none. That was in his case in chief on his petition.
No, and again, this is why I overruled objections on scope early on. It's a non-jury trial. There's a claim and a counterclaim. I gave both lawyers latitude to ask their questions so that we could efficiently address the legal issues. I don't ignore the prior testimony that was given with regard to the furniture. So that's a point in controversy, but I want to come back to the technical point as to what is the contract. I've already ruled in your favor that there was no contract on the car. Is
Correct.
there a contract on the furniture, or does it suffer from similar flaws?
The consideration was they were both going to retain the furniture. At the time, they were living as a married couple, basically, without the marriage. They agreed to sign and get the furniture, and they agreed to pay the bill together. That is the agreement that they made. It was an oral, verbal agreement and an understanding that they were to purchase the furniture together. That's why they're both signed on it. If Your Honor is aware of a city furniture contract, there is no co-signer. Everybody who signs on it is equally liable.
Nobody's,
agreed.
says you. Says you. Nobody's established that in the slightest. There's some dispute as to what it was. Mr. Pellegrino characterized it one way and Ms. Giordano characterized it another. Nobody's brought forth any document.
Well,
but again,
either way,
the contract is the verbal
agreement to pay the bill.
And you're saying that doesn't suffer from statute of frauds because it didn't have to do with the purchase of goods.
Correct. The statute of frauds only applies to the purchase of goods. And secondly, it's to contracts that can't be performed within a year. This was supposed, the whole thing with the interest was the plan was to have paid it off within a year. And that's why the interest hit in June, as my client testified, that's why the interest rolled in June, because they didn't pay it off within that year. Secondly, again, the agreement between them was to pay the bill. It wasn't to buy furniture.
What were the terms of the agreement?
That they were going, my client testified they were going to pay the bill equally. Until the day, she testified until the day he cleared out the joint account. And then she paid unilaterally thereafter. And then secondly, even if the court doesn't find that strong enough, I do have an unjust enrichment count. They took out a loan together. They purchased the furniture together. He maintained most of the furniture. By choice or not, he has it, he uses it, it's in his home. And he's paid nothing towards it except one payment as per his own testimony.
Okay, I'm still on the contract one first. Mr. Zermay, you raised statute of frauds. Have you pulled any cases that will help give the court guidance with regard to whether this suffers from a statute of frauds problem or not?
Judge, respectfully, we don't need any case law. The law is, I hate to quote Willy Wonka and the Chocolate Factory for the, I think, second or third time this case, but section 725.01 Florida statutes clearly and unambiguously states, no action shall be brought whereby to charge defendant upon any special promise to answer for the debt, default, or miscarriage of another person, unless the agreement or promise upon which such action shall be brought, or some note or memorandum thereof, shall be in writing and signed by the party to be charged therewith, or by some other person, by him or her thereunto lawfully authorized. It's all there, black and white, clear as crystal. This contract is not enforceable.
Your Honor, if I may respond to that briefly.
Okay.
He just proved my case for me. 72501, promise to pay another's debt. This isn't another's debt. They're both equally on the credit card. He signed on the credit card. He's testified he was one of the debtors. This isn't a promise to pay another's debt, and therefore this section of the statute of frauds is inapplicable as well.
Well, let's play that out. If it's not a promise to pay another's debt, I think then logically what you're suggesting is it was a promise to pay his own debt.
Correct. His half of that debt was his. They both signed on the debt.
Okay. Well, how can he breach a promise to pay his own debt? That would be a contract with himself in theory.
Well, no, because it's affecting her. It's a joint card.
Okay.
It's his debt, but she's being damaged because they're both on the card and they're jointly and severally liable on the debt. But half of it belongs to him.
Okay. I'm going to grant directed verdict with regard to count one. I do think that the statute of frauds is in play here. The reality is that both have taken on a debt, and depending, regardless of how that plays out, paid, unpaid, one paid all, the other paid all, it does not give rise to a cause of action. We do not have anything here that would give rise to a cause of action for breach of contract. There can be no oral agreement of this nature. So I'm going to grant involuntary dismissal on count one. Now, Mr. Zermay, let me turn back to you. Your motion for involuntary dismissal on count two, unjust enrichment. Please make your argument on that, and then I'll hear from Mr. Fate.
Yes, Your Honor. As to Ms. Giordano's testimony, even if we were going to take her testimony as gospel, the furniture is still technically both of the parties, effectively, if we're going to go about what she says. I mean, and also a testimony that was offered before the tribunal tends to indicate that she sort of abandoned the furniture. This is, effectively garbage, Judge. There could be no unjust enrichment for effectively dumping stuff at my client's house and leaving the residence. That's just not what unjust enrichment's there for. If I was going to, leave an item that I don't want at, Mr. Marinsky's property, and then I could sue him I would not be able to sue him for unjust enrichment. That's just not what the purpose of this common law tort is for. And as to damages, they have not presented any competent or substantial evidence to the tribunal to demonstrate that she has any damages. She's not able to present any articulable damages stemming from the furniture. There's just nothing there. There's no evidence for the court to go on. And for that reason, plaintiff would respectfully request for you to grant a directed verdict as to defendant's unjust enrichment claim.
Okay, Mr. Faden, your response.
Your Honor, he testified clear as day. He co-signed on the furniture. He kept a portion of it. He's therefore liable. He's enjoying the usage of that furniture. It is in his home. He's using it currently. Today's value doesn't matter. The value on that debt is what matters.
And I want to, this may or may not actually prove relevant, but my memory is he said, take it. In fact, she even said he insisted she take some of it, but it doesn't work in her place So she only took a minority of the pieces.
Well, that was in regards to the 2 bar stools.
Actually, I think it was all of it. She said it's furniture for a large house and she has a small place.
I don't believe that was the testimony. I believe that was into the bar stools. She only wanted to take 2. He tried to make her take all 4, and she said she didn't have room for all 4 at her bar.
I do recall it as to the bar stools, but what about everything else? There's no suggestion that she wanted it and he wouldn't let her take it. I don't think I've heard a shred of that from either side.
In my cross motion, his letters to me.
Hang on, Ms. Giordano. My question's to Mr. Faden. I don't think there's been any testimony from either of the parties that Ms. Giordano made a demand for the return of the furniture and that Mr. Pellegrino refused that and insisted that he be permitted to keep it.
I don't believe demand is part of an unjust enrichment claim, Your Honor. That's, if you looked into the factors, demand is not part of it.
Let me state it another way. Anything that would rebut a suggestion that she abandoned the portion she left behind.
Well, still, the claim, Tracy, you can't speak now. Under the unjust enrichment, she conferred a benefit to him by leaving the furniture there. He accepted that benefit, and he should have known that he would have to pay for that benefit of keeping the furniture.
I have what I need. Motion for involuntary dismissal on count 2 is also granted. I believe that disposes of all claims.
I believe it does.
I have found that there is no contract on the prior claim, a primary claim, which means that we don't have an attorney's fees dispute because that contract is void. So I think that addresses everything. I am deeply sympathetic to both sides. Incurring debt in the course of a romantic relationship is unadvisable for good reason. I know you both go forward a lot wiser, but ultimately there is no recourse in a courtroom for the difficulties that each of you has suffered. I grant that these are difficulties, but you each live with the stress and the risk and the possibility that the other won't hold up their end of the deal you jointly made. Mr. Pellegrino's suggestion on the city furniture is what we call a distinction without a difference. Your credit is just as implicated as hers, and you may ultimately both be sued by city furniture. I certainly preside over those suits all day, every day. I hope that you all will work toward trying to ensure that both of your credit is preserved, but none of these legal claims forward or in return stands in a court of law. So I'm going to close the issue there. I'll ask Mr. Zermay, in light of the court's ruling, involuntary dismissal of both counts of the primary claim and involuntary dismissal of both counts of the counterclaim. Does plaintiff believe there is anything else the court needs to address today?
Not at this time, Your Honor.
Mr. Faden, do you believe there's anything else? I know you may disagree with some of this, but do you believe there's anything else the court needs to address before adjourning today?
No, Your Honor.
All right, that'll conclude our proceedings. Madam Clerk, all we had offered and all we had admitted was a single Exhibit A by plaintiff, so that'll be our record.